Call the third case on this morning's docket, case number 120518, in the matter of Kevin T. Cure, respondent. While counsel is approaching, please proceed. I'll announce that we have a recusal on this first case. Actually, two recusals. Our senior judge is sitting in for Justice Lukert, and sitting in for the recused Justice Beyer is a distinguished jurist to my left. This is the Honorable Kathleen Sloan. She sits in Olathe in the 10th Judicial District. She has read all the materials on this matter, and she will be resolving this during our case conference later today. Judge Sloan, on behalf of my colleagues, I want to thank you for helping out the Supreme Court.
I'm honored to be here. Thank you for inviting me.
Thank you. Counsel may proceed.
May it please the Court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Mr. Chief Justice, I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving Kevin Cure, an attorney who was admitted to the Kansas Bar in 1991. Mr. Cure is also a member of the Missouri Bar and was admitted to that state's bar in 1990. 3 disciplinary complaints were filed against Mr. Cure. They were heard before a hearing panel on September 21st, 2018. The first complaint, DA 12513, concerns Mr. Cure arriving at the Galena, Kansas Municipal Court on March 11th, 2016 while intoxicated. At that time, Mr. Cure was a city prosecutor for Galena. Due to being intoxicated, he was incapable of representing the city in court, which caused the matter scheduled for that day to be continued. Later that same month, on March 29th, Mr. Cure was arrested in Joplin, Missouri for DWI. At the time of his arrest, he was on probation for a prior DWI that he had received in 2014. The second complaint, DA 12600, concerns Mr. Cure's arrest in Joplin, Missouri on July 27th, 2016 for DWI. At the time of his arrest, Mr. Cure's driver's license was suspended, and he was currently out on bond for his earlier March 2016 DWI arrest. Due to his July 27th arrest and subsequent incarceration, Mr. Cure was unable to appear the next day in Cherokee County District Court for a docket involving juvenile offender and child in need of care cases. Mr. Cure had 10 cases scheduled on the docket that had to be continued as a result of his absence. The third and final complaint, DA 12954, concerns Mr. Cure being arrested and charged in Jasper County, Missouri with felony DWI on September 21st, 2017. Again, at the time of his arrest, Mr. Cure's driver's license was suspended. Mr. Cure failed to report his felony charge to the Disciplinary Administrator's Office within 14 days as required under Supreme Court Rule 203C1. On June 26, 2018, Mr. Cure pled guilty to felony DWI. He received a suspended 2-year prison sentence and was placed on supervised probation for 5 years. Based on Mr. Cure's prior DWI convictions, on July 3, 2018, the Missouri Supreme Court issued an order indefinitely suspending his Missouri law license for at least 6 months. On July 13, 2018, this court, pursuant to Supreme Court Rule 203C, temporarily suspended Mr. Cure's license to practice law in the state of Kansas. His license has remained suspended since that time. Prior to Mr. Cure's disciplinary hearing on September 21st, 2018, he filed a timely request to be placed on probation and provided a proposed probation plan to myself and the hearing panel members. He also entered into a stipulation regarding the underlying facts and rule violations. Based on the stipulation and evidence presented at the hearing, the panel concluded that Mr. Cure's conduct violated 8.4b, committing a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, 8.4d, engaging in conduct that is prejudicial to the administration of justice, 8.4g, engaging in any other conduct that adversely reflects on a lawyer's fitness to practice law, and Supreme Court Rule 203C1, failing to report a felony charge to the Disciplinary Administrator's Office within 14 days. At the hearing, the Disciplinary Administrator's Office recommended that Mr. Cure be indefinitely suspended and that the indefinite suspension begin to run from July 13, 2018, the date of his temporary suspension. In case the panel believed a definite term of suspension was appropriate, The Disciplinary Administrator's Office recommended that Mr. Cure be required to undergo a reinstatement hearing under Supreme Court Rule 219, and that he be required to establish at the reinstatement hearing that, in addition to the factors outlined in Rule 219D4, he was no longer on probation in Missouri for the DWI. At the hearing, Mr. Cure requested that he be placed on probation. The hearing panel ultimately recommended that Mr. Cure be suspended for 18 months and that the suspension begin to run from July 13th, 2018, the date of his temporary suspension. The hearing panel also recommended that Mr. Cure be required to undergo a reinstatement hearing under Rule 219 and that he be required to present evidence showing that he successfully completed the DWI probation program and that he had fully complied with the terms of his current KLAP monitoring agreement. The hearing panel's report was filed with the Appellate Clerk's Office on January 3rd, 2019. On January 10th, Mr. Cure filed a statement pursuant to Supreme Court Rule 212C stating that he did not wish to file exceptions to the hearing panel's report. Accordingly, the hearing panel's findings of fact are deemed admitted at this time. On March 7th, 2019, Mr. Cure filed an affidavit with the Clerk of the Appellate Courts pursuant to Supreme Court Rule 211G5 stating that he was in compliance with the terms and conditions of his proposed probation plan. At this time, the Disciplinary Administrator's Office is still recommending that Mr. Cure be indefinitely suspended from the practice of law. Mr. Cure engaged in repeated instances of criminal behavior. Between March of 2014 and September of 2017, he was arrested 4 times for DWI. At the time of his last 3 arrests, Mr. Cure was either on probation for an earlier DWI conviction or was the subject of bond conditions as an earlier DWI arrest. At the time of his last 2 arrests, his driver's license was suspended, so he couldn't legally drive a car, let alone drive one intoxicated. Mr. Cure's actions also affected his clients. In March of 2016, while city prosecutor for the city of Galena, he arrived in municipal court intoxicated, resulting in the matter scheduled for that day being postponed. In July 2016, he was unable to appear in Cherokee County District Court due to being arrested the prior day for DWI. Finally, though I commend Mr. Cure for the recent steps he has taken to address his alcoholism, those steps have largely resulted from Mr. Cure being convicted of a felony DWI and being ordered to comply with the DWI court program in Jasper County, Missouri. I would point out that Mr. Cure testified at his disciplinary hearing that he continued to consume alcohol until the evening before his sentencing for the felony DWI, which would have been June 25th of 2018. Based on Mr. Cure's conduct, I believe the appropriate sanction is indefinite suspension. In support of this recommendation, I would ask this court to consider its decision in a case with substantially similar facts, In re Laskowski, 282 Can, 710, 2006. In that case, the respondent was convicted of 3 DUIs during a 3-year period, the last conviction resulting in a felony. The respondent violated the terms of his probation for the 3rd DUI conviction by consuming alcohol. Despite an approximate 2-year period of abstaining from alcohol prior to his disciplinary hearing, this court imposed the sanction of indefinite suspension in order for the suspension to run retroactively from the time respondent's license was temporarily suspended. I would ask the court to impose the same sanction here. If the court disagrees and believes a definite term of suspension is appropriate, I would request that Mr. Cure be required to undergo a Rule 219 reinstatement hearing. At his reinstatement hearing, Mr. Cure should be required to establish not only the factors outlined in Rule 219D4, but also that he's been successfully completed and been discharged from criminal probation in Missouri. Unless the court has any further questions from me, I would waive the remainder of my time and address any questions during rebuttal.
So to clarify, it's indefinite suspension, but retroactive to the date of the temporary suspension, which was July of 2018.
Yeah.
Is that your recommendation?
Correct.
Thank you, Mr. Vogelsberg.
Any further questions? Thank you, counsel.
Oh, I have one. On the, I guess I would call it the tail of the criminal activity, the probation and all that. When's all that run out?
From what Mr. Cure testified and what counsel has told me, because he's participating in the DWI program in Jasper County, the earliest he can be discharged from probation is 18 months. And so based on running from June 26, 2018, that would roughly be around January 2020. is the earliest he can be discharged from probation.
Any further questions? Thank you, counsel.
May it please the court, I'm Steve Angermeyer, and I represent the respondent, Kevin Cure, and he's present as well. We are ready to proceed, Your Honors. We have not filed exceptions to this panel report, and we do not contest the findings. All those things happened. There's no denying it. They did happen. It's the nature of addiction. The person goes further than they want to go, keeps them longer than they want to stay, and makes them pay more than they want to pay. And that's what we have here. Downward spiral, really no way out. And I can tell you that Kevin wants to address his wrongdoing. I can tell you he's changed. He's aged more than his chronological age. His health was affected. Families and friends were lost. His career was damaged. He's significantly changed. We believe we have put together one of the more comprehensive probation plans that may not be seen by this court prior to this case. Perhaps it has been, but it's a very comprehensive plan. And last week, we filed an update as to Kevin's progress with that probation plan. It essentially covers the Lewis Clothier plan and adds several requirements to that. And that was the case where Mr. Hazlitt stated that this was one of the most comprehensive plans he had seen to date. It adds the requirement of the multi-state ethics exam, which Kevin has taken and passed. It covers the issue at hand, driving under the influence. He is required to have the ignition interlock device for 10 years in his car. A little side note, this is a device you probably know, but familiar with the recent update, you blow into it to start your car, and then every 15 minutes while you're on the road, you blow into this thing, so you hyperventilate essentially while you're driving. Additionally, the plan incorporates the DWI probation plan, the underlying Missouri DWI probation plan. Since that time, since we had the panel hearing, Kevin has taken mediation training. Yesterday, he was in Salina, Kansas, and took the abstractor's exam. I didn't realize it was yesterday. I called him on the phone. He said, I'm coming from Salina. I'm taking the abstractor's exam. He's had 8 months of sobriety. He's nearly halfway through his DWI court probation. When his probation officer wrote the letter, that is Nikki Moore, when she wrote the letter, she said he's in phase 3 of a 4-phase program. We recently learned it is now a 5-phase program. So he's in phase 3 of a 5-phase program. It's designed to last 5 years. He has completed everything within the minimum time. He has done all of his community service. He's paid his fines and costs. And the letter indicates no citations. That means there was no violations of his probation. He expects an early release of January of 2020. And we have completed what we could complete of the attorney probation plan to date. Obviously, he's not practicing law, so we don't have the supervision in place, but that gentleman is ready to supervise once he's allowed to return to the practice of law. That's Mr. Barrett. He completed 75 hours of SATOP counseling. That's the Substance Abuse Traffic Offenders Program, and 15 of those hours was one-on-one counseling. He takes random urinary analysis, and that's 8 times per month. His CLE is current for our reporting period. He was granted the ability to drive by the judge in Missouri. He has not yet taken the driving test. He expects to take that within the week. I prompted him to take that prior to today's hearing because he's being driven everywhere he goes right now. And he said, I really need to spend time studying for the abstractor's exam, and so I really don't want to study for the driving test. Just want to make sure I pass the driving test when I take it. He is willing, as we stated, to perform, if this court orders, to perform pro bono work and bids criminal representation if the court believes that's appropriate. So he's adding that as an additional a requirement if the court so requires. I would advise the court that there is a network of individuals that have eyes on Kevin, and it's extensive. K-Lap was here a few minutes ago. She had to leave, but Bryn Rose, we've been in constant contact with Bryn. She has been very instrumental in assisting us in this case. We have the K-Lap attorney monitor, Larry Prowser. He wrote a recommendation letter for Kevin. And we also have another K-Lap volunteer down in Southeast Kansas. We have the DWI court team, his AA sponsor, and importantly, we have the Southeast Kansas, I call it network. It's kind of like no other. We have a very close-knit group of folks in Southeast Kansas. I schedule a monthly CLE for our attorneys, and sort of an unintended result of that is I've become the town crier, if you will, for the attorneys and judges in Southeast Kansas. For example, if an event needs to be scheduled or noticed, they call me. You may remember I assisted when the Supreme Court came down to Southeast Kansas, and so that's kind of my calling, and I enjoy doing it. And so I pass information along with attorneys and judges quite frequently. I can also tell you this, that the bar cares very deeply about Kevin. And when they learned I began helping Kevin, I began getting calls from courts, from judges and attorneys about what Kevin was doing. And I was receiving calls all times of day and night. And that has helped greatly in moving us to the position we're in right now. And I will tell you that if he has a misstep, they're going to tell me. I'm going to learn about it. And we have several things in place. KLAP will know about it. Our judges will know. The volunteers, the KLAP volunteers will know. The DWI court will know. Kevin's counselor will know. His probation officer will know. And most importantly, I will know as well. We have a bunch of eyes on Kevin. And we intend to keep it that way. As a side note, we believe the Missouri Supreme Court is in the process of reinstating him on a probationary status. I included a letter from their counsel, Sharon Whedon, and all indications are that they'll move to the, we don't have it yet, but all indications are that they'll move to a probationary type process in Missouri. And we look forward to having that fairly soon. I want to make reserve a few minutes to let Kevin address the court. So Kevin, why don't you come on
Before
up?
you do that, counsel.
Yes.
Opposing counsel has asked us to follow our decision in Laskowski.
Right.
And would either you or your client address for us why you disagree with that?
I think both of us can, but I would advise the court Laskowski had no probation plan. And we do, and it's extensive. It's maybe one of the most intense probation plans we've had. Kevin has imposed on himself a strict burden, and it has impressed me. His attention has been gotten, and I think he also wants to address that issue well, Your Honor, if you would allow him to do so.
Yes.
Kevin, come on up.
Good morning, Justices. May I address the court?
Yes.
All right. I must say to all of you, it's with deep regret and a strong sense of shame that I am here today. As attorneys, we are held to the highest standards of ethics, I believe, and should be. And I had a brief period, maybe it wasn't brief, it was 3 or 4 years, where I didn't uphold those standards. And I'm glad I had no prior record of any ethics violations with this court, but at some point drinking did affect me. But the importance of upholding those standards is that we are the people that help the legal process benefit the lives of others, whether it be the Supreme Court, the judges, or the attorneys. And you know what? I wasn't mindful enough of that for a while. And I stand before you today humbled and changed. And I don't know if I have the words to convince you, but I will speak from my heart and hope that you will consider my arguments. The attorneys in this case did act better than I did. Mr. Steele, Ms. Gayoso, Judge Marsh, they all made a report of my ethical violations to the court. They upheld the standards that should have been upheld, and they did. And I have made an apology to each of them, and I believe they've accepted it. Judge Marsh has indicated to me very recently that he would welcome me to practice before him in his court, as I'd practiced with Mr. Marsh for about 20 years. The disciplinary administrator's office, Mr. Vogelsberg and Mr. Hazlitt, have been nothing but professional and courteous and fair. So I understand the duties that they must fulfill, and I understand that they are making the argument they believe is best. I hope to convince this court otherwise. My life before drinking, well, I was lucky. I started practicing in the early 90s, as said, and in 20 years, I probably drank 3 times. I had a great relationship with my ex-wife, and I had a wonderful daughter that still continues to live with me and excel in college. A lot of my practice was in governmental law, whether as a county prosecutor, a city attorney, or a county counselor. It gave me so many opportunities to change the lives for the better of others, and I put in a lot of time, and I enjoyed it. Serving my hometown of Galena was a calling. I wouldn't tell them, but they wouldn't have had to pay me to do it. I mean, that's how much I enjoyed doing that job. It's a poor town, and we transformed it in 15 years, and we put in a lot of work. And that is one of my deepest regrets, is that I lost that position because I could not manage my drinking, rightfully so. After the divorce, I was followed shortly by the Joplin tornado destroying my house. And I found myself living at a large casino nearby because there was a shortage of hotels. And I stayed there for 5 months. Eventually, I found myself, to fill time in the evening, at the bar downstairs. And that began my course of drinking after nearly a 20-year period of abstinence. For the first 4 years or so, until my DWI arrest, it was fairly under control. It was in the evenings, wasn't interfering with me during the day. But there was a change at that point. I didn't see it coming on, and I lost control, and it owned my life. Every day was thinking about what I do to have my drink. When can I get my functions that I have to do done so I can have my drink? I kept getting up earlier just so I could get everything done to start earlier in the afternoon. And eventually, my life was based around it, and I was not in control. I truly wasn't. That doesn't change that I did a remarkably poor series of acts, and I did not uphold my obligations to society in committing DWIs, because they pose a risk to society, and I know that. I could convince myself I was slowing down, paying attention, not being distracted by anything, but the fact is I could have passed out. I could have hurt someone, and to society I also apologize. I would go to the bars. I would many times take a cab, but sometimes I got too impaired and my judgment wasn't right, and I did choose to drive from those bars to my house. I got hospitalized for pancreatitis twice, and it's extremely painful. There were many other adverse consequences, the deteriorating relationships with the people I care about and my colleagues, and there were financial consequences. I lost the Galena job, as I mentioned earlier. And it took me a while to finally have, none of those things pushed me to the decision I needed to make, which is start my sobriety. Mr. Vogelsberg is right. It probably took my felony plea to DWI last year to make that change. And for the first 2 months, I believe that is what drove me to not drink, worrying about incarceration. But over time, things changed. I think at about the 2-month mark, I realized, I'm doing it because it's the right thing to do. And it's not out of fear of incarceration. I had extremely good confidence, but it's still guarded that I could meet those conditions. And I made a promise to the judge that day, one I hadn't kept to other judges, but to that judge, I felt in my heart, because of a more extensive process during a felony plea, that as I looked him in the eyes, I was saying, I promise you, you put me on probation, I will strive to do everything that you ask me to do, and I will change, and I believe I have. One thing, 43 hours in jail doesn't sound like a long time, but when you're in solitary confinement, as this local jail was, you realize it is not something you want to return to. My roommate slept the entire time. There was no orientation to time. There was no outside stimulus. You were alone with your thoughts. Your only acclimation to time orientation was the 3 meals a day you were served. And not to mention just the regret and shame and how did I end up here thoughts that just troubled me immensely. I'm sorry, I thought you were asking me a question. What I love about my sobriety, and the most important thing at this point, has been that I don't have to make those promises to my daughter that I'll stop drinking. And she has remarkably thrived throughout this and kept on course. And thank God I did not change her. And when I first hired Steve, he said, we have to fix the human being first before we fix the lawyer. And he's right. And into my life came all of the resources that he spoke about. And I was going to speak about them, but I'm realizing I'm short on time. At first, it was a slow start. And when Brent talked about fulfilling the promises, it fell on deaf ears. But once I got on probation and I got past the withdrawals and I got the counseling, things changed. And the AA family, the support group, there's a lot of sobriety in that room, a lot of wisdom that is just, every day I leave those meetings with insight I didn't have before. And the thing I got that has been another incredible blessing has been the spirituality I lost since 1992 when my sister committed suicide, but I have it back, and it's missing for a long time. I hope you'll approve the probation plan. I based it off of what Mr. Clothier, if I'm pronouncing that correctly, stated. And Mr. Hazzard stated it was more stringent than it needed to be, if I recall that correctly. I tried to add 3 more things to make it that I clear to you that I'm very serious, including the multi-state, including the 10-year intoxilizer, including the DWI court. You asked the question earlier about the probation. The DWI court is somewhat complicated. It's a program that if you go through the 5 phases, you can be completed in 18 months. Often I'm told by the probation officer, Nikki Moore, that he sometimes adds another 6 months, Judge Moulton. The probation on paper is for 5 years, but often it terminates at either the 18 or the 24-month mark. The last 6 months of that 24-month, if I stay on course, isn't really DWI court supervision, it's just regular probation supervision.
I had a question about the letter from, and I'm not sure who can answer this, but
Yes, sir.
I don't know the terminology from the Missouri disciplinary side of things, and the letter from Ms. Wheaton, I think's her name, indicated that she was likely to recommend a period, that you had filed a motion, and I assume that's for reinstatement, and she was likely to recommend a period of probation consistent with the criminal probation period. My question has to do with, from the Missouri disciplinary side of things, is probation the same thing as suspension Did you read that letter to mean that you wouldn't be allowed to practice law if they do what they said they're going to do, that you wouldn't be allowed to practice for another 6 months or some period of time commensurate with that?
Your Honor, to the best of my knowledge, I know the Kansas process much better because 95% of my practice was here. But I believe there will be a suspension hanging over my head, and on condition that I complete the probation. Because they sent a plan out before that when I only had the 3 misdemeanor DWIs, and only was probably not a word to use there. And all I had to do was sign it and return it. But I said, you know, I have a pending felony one. I'd rather just wait and have that resolved and let you make your decision.
But my question is, the word probation in that letter is meant to imply conditional, you'd be allowed to practice, but it would be under a probation plan, as opposed to probation being another word for continued suspension.
It's not continued suspension,
Okay,
Your Honor.
I'm just trying to get...
practicing, and I hope she adopts the conditions I had, because the previous plan had far fewer. I wish I'd included pro bono hours because I think they're important, and I wish I'd included a requirement to sign up for the bids list. There aren't many attorneys that are qualified to do the higher level felonies, and there's a shortage, and that is something I've stayed away from for 10 years after mostly being the only attorney in Cherokee County for about 10 years doing those. So I could add value there, I hope, and certainly it's a public service.
Excuse me, counsel, we're
Yes.
going to need to wrap this up.
Okay, if I may have one more minute.
One more minute.
All right. Okay, about Laskowski, yes, he had 3 crimes, but he had no probation plan he submitted to this court. It was also 10 years removed, 12 years removed from now. I think there's been a change in the understanding of the effects of alcohol on people. I saw your decision in Hubin. She too, like me, had several offenses, including 2 felonies instead of 1, that occurred in a short order. One of hers, a misdemeanor, was remote in 1991. She had a longer period of sobriety, but what quantifies appropriate period of sobriety, I don't know. But Mark McDonald, my counselor, trains and credentials substance abuse counselors for the state of Missouri, and he has been more significant and the best one I've ever been before. If this court grants me the privilege to practice law again, or puts me on probation, or whatever it decides to do, I will accept it graciously. And I gratefully thank you for your consideration of this matter.
Thank you, counsel. Thank you both for your arguments.
May it please the court. Unless the court has questions for me, I would waive rebuttal.
Mr. Bosberg, you indicated that Mr. Cure had gone ahead and admitted to the hearing panel that he continued drinking up to the night of his felony sentencing.
He
Is
did.
that correct? Was that information that you had, was that known to the court in Missouri, or is that just something that he admitted?
He was forthcoming with that. Prior to the hearing, I had a meeting with him and his counsel where he admitted that at that meeting, and his testimony at the panel hearing was consistent with that his last drink was the night before his sentencing, so his drink would have been June 25th, 2018.
Something you wouldn't have had but for his honesty then?
That's correct.
Okay.
Based on what you have heard today, particularly from the respondent and your knowledge of the facts of this case, you are still sticking with your original recommendation?
I am. I believe that the court's prior decision, especially in Ray Laskowski, indicates that indefinite suspension would be appropriate in this case because of the repeated criminal conduct that took place during a short period of time. I'd also note that the respondent's relatively short period of sobriety, which began June 26th of 2018. Again, I would distinguish that from in Ray Laskowski, where Mr. Laskowski had about a 2-year period of abstinence from alcohol between his last drink and his panel hearing. And in Ray Hubin, which counsel cited, that's 302 Can 979 2015. I believe Ms. Cuban in that case had a period of 4 years of sobriety prior to her panel hearing, but she was granted probation in that case. Another case that the court may consider in determining what sanction is appropriate in this case would be In re Harrington, 296 Can 380, 2013 case. That incident, the attorney ingested cocaine and excessive amount of alcohol, was involved in an accident on K10 by driving the wrong way down K10, and that was the sole basis for the disciplinary complaint against her. I should also say that she was also charged. She was charged with misdemeanor DUI, misdemeanor battery, misdemeanor obstruction of official duty. In that case, the court imposed a 2-year suspension, but after serving 3 months, went ahead and suspended the remaining term of that and put her on probation. And so that would be another case the court could consider. But again, that was in re Harrington, that was the only incident that took place in that case. That was what the disciplinary complaint was based on. Here we have multiple DWIs, multiple instances of criminal conduct, which I think makes this case distinguishable.
All right. Any more questions? Thank you, counsel. We thank all counsel for the arguments this morning. The court will take this matter under advisement